Good day, ladies and gentlemen, and welcome to the Setting the Goals, Building the Team, Managing the Budget webcast. My name is Fab, and I'll be your operator for today. At this time, all participants are in listen-only mode. If at any time you require operator assistance, please press star followed by 0, and we will be happy to assist you. I would now like to turn the conference over to your host for today, Mr. Maury Leiter. Please proceed.
Thanks, and good afternoon, everybody, and welcome to our webinar on defending mass tort litigation and class actions. Today we're going to talk about some aspects of managing different types of complex litigation. And today, as you know, we're focusing on setting the goals, building the team, and managing the budget. I'm Maury Leiter. I'm a partner at Arnold & Porter in Los Angeles. I'm a litigator handling complex litigation and trials in mass tort, product liability, and other commercial cases. I've been here at Arnold & Porter for 21 years. Before that, I spent several years at the U.S. Attorney's Office in Los Angeles handling white-collar criminal prosecutions. Also with us is Daphne O'Connor. Daphne?
Yes, hello, Daphne O'Connor. I am Vice President and Associate General Counsel at Altria Client Services. I've been here for 4 years, where I manage commercial and product liability litigation, which includes mass torts, appeals, trials, the gambit of litigation. Before that, I was at Arnold & Porter for 14 years in both the D.C. and the Denver offices, where I did, mostly pharmaceutical work and product liability work as an outside counsel.
And Tom Stover.
Good afternoon. My name is Tom Stover. I'm a partner in Arnold & Porter's Denver office. I've been practicing with the firm now for about 17 years. The bulk of that time has been spent defending the firm's clients in mass tort and product liability litigation around the country in all phases of that litigation, from its various very earliest stages through trial and into post-trial appellate work. And that's it.
We had also hoped to have with us today Jessica Mayer, who is a Vice President and Managing Counsel of Cardinal Health based in Columbus, Ohio. But unfortunately, she had an emergency earlier this morning and isn't going to be available to join us, and she sends along her apologies. We have a relatively small number of slides which we'll share with you, which we hope will introduce the topics we're going to talk about with our panel of in-house and outside lawyers. And we're hoping we can offer some varied perspectives on some of these issues. As you heard, the lines for our participants are muted. So if you have any questions, please use the chat feature tool within WebEx and send any questions to the host. We will try to get to as many of the questions as we can towards the end of our time together as time permits. And of course, if we don't get to your questions or you have questions later, feel free to contact any of us offline at your convenience. If you need any assistance during the webinar, please press star 0 and somebody will be available to assist you. We are recording this event and we are going to post it on the Arnold & Porter website, where it will be available to the public and to you if you would like to listen to it again and again. Let's begin. The kind of cases that we're going to talk about today that raise the organization and management issues that we're focusing on could involve any number of substantive areas. But we're going to focus today conceptually on mass tort and product liability cases that involve consumer products or pharmaceuticals or medical devices, or the kind of environmental exposures that can lead to significant legal issues in a variety of fora for a company. And of course, the legal issues involve many of the items that you see on this slide 4. There are often personal injury cases that, depending on the nature of the litigation, could be confined to a single state, or they could be in state and federal courts throughout the country. If there are personal injury actions, There may be a large number of individual cases. It's not uncommon in litigation such as this for there to be thousands of cases. Or the plaintiff's lawyers may try to aggregate individual cases into group actions, which we see in a number of types of these cases where multiple plaintiffs sue in one group lawsuit. We've also seen plaintiffs' lawyers try to bring personal injury claims as a class action, although those are usually inappropriate types of cases for class action treatment where there are personal injuries. There may be separate claims or separate cases for purely economic injuries, which might well be brought in individual or multiple class actions. In this type of litigation, the plaintiff's lawyers tend to be reasonably well organized, sometimes before the litigation is even filed, but frequently as they work together as the litigation proceeds. And they are almost always very well funded. And the company may face not just these civil lawsuits brought by individual plaintiffs, but proceedings brought by regulators at the federal level in the United States, sometimes regulatory issues from other countries. There might be regulatory issues brought by state regulators. As many of you know, in recent years, state attorneys general have become much more active in pursuing issues related to mass tort, products kinds of cases, and other things that used to be left to the federal government and the civil bar. And of course, there are also the possibilities of proceedings by the Securities and Exchange Commission, private actions brought by the company's shareholders, and in some instances, the possibility of criminal investigations either at the federal or at the state level. You know, when these kinds of lawsuits arrive, they're characterized by some fairly common factors, which is going to be the basis for some of the management and organizational and strategic concerns we're going to talk about today. It's almost always the case that in order to produce discovery and prepare the company's defense and tell the company's story, there are large numbers of documents, both paper and electronic, to be gathered, reviewed, coded, and made accessible. There are company witnesses, often large numbers of company witnesses, to be prepared for their testimony and to be interviewed to help build the company's case. Particularly where there are personal injury cases, which may be scattered about the country, there are large numbers of individual plaintiffs whose cases need to be discovered and litigated individually and in many cases simultaneously. And that involves collecting documents from each of them, developing and deposing fact witnesses in each of those cases, and exploring and developing medical and scientific defenses as appropriate in each of those cases. And on a company-wide basis, the development of large numbers of expert witnesses involving what can often be highly specialized and broad scientific and medical areas. We believe that one of the keys to managing this litigation and organizing the company's defense is work that's done at the very beginning to create an initial assessment of what the issues are and how the litigation could proceed, which brings us to slide 6, and Daphne is going to talk about that.
Thanks, Maury. Yeah, I mean, obviously, one of the first things you have to do when you get sued in this context is identify who are the key players, who are the company employees who may or may not still be at the company, who were involved with the facts surrounding the case. And it's important to identify those people early because oftentimes, if you've got plaintiff's lawyers who are savvy and sophisticated, they will try to take discovery very early on because they want to get to the witnesses before they're well prepared, before they have spent lots of time with the lawyers, understanding number one how to testify, and number two, what the company story is. And so it's important to identify those people and also to really begin preparing them. A lot of times the folks in the company and former employees who are involved with the facts have never testified before. And so, not only is it sort of marshaling all the facts that you're going to want to tell, the story with, but it's also preparing those people to be witnesses, which, as many of you know, sometimes doesn't come intuitively. So identifying the key employees and then assigning lawyers to spend time with those key employees is critical, and it's critical to get that done, I think, very early on. The other thing is, of course, the documents. As what happens a lot of times in these types of cases is the plaintiff's lawyers will use discovery as a weapon. They'll seek documents, particularly in courts where they have some sway with the judges, and they'll try to get them on a very short timeline. And so before any of that begins, it's important to figure out where your documents are, come up with a plan for how you're going to locate and review documents. There are so many wonderful tools these days. Technology is completely different than it was 20 years ago. And so figuring out in advance what sort of technology you're going to use for your document review, whether you're going to use predictive coding, figuring out what vendor you're going to use to get that done needs to happen very early on so that you can get way ahead of the 8 ball, so that when your initial disclosures are due or when the plaintiffs start seeking documents, you're not starting from square one. You're actually, moving down the road of being prepared to actually produce documents that, ultimately, more than likely, you're going to have to produce. So spending the time and the resources to do these two things early on is well worth it. The case is not going to go away if it's this sort of case. This work is going to have to get done, and there's no reason not to sort of start it immediately in most situations. And then on the law, it obviously depends on what kind of case it is, but particularly if it's some sort of a novel lawsuit or a class action, these kinds of cases, you want to put together a legal team to really start thinking about what the legal issues are going to be, sort of soup to nuts. You may have early motions to dismiss. You may have, you may want to deal with the class certification issues early, but all of those things are going to fold into a long-term legal strategy. And so, even very early in the case, you want to think about, what your appellate issues are going to be, and your strategy on the legal front needs to start early and think all the way through to sort of your end game. And so putting together a legal team early on, oftentimes, in my view, it's helpful to have folks from different law firms because they can play sort of a checks and balance on each other. But to put together a group to think through all the legal issues early makes a lot of sense. And then in terms of the risks involved, in your initial assessment, you obviously have to take into account the risks. If they're safety risks, you've got issues related to, whether the product should stay on the market or be removed. You've got the economic risks, which relate to the potential liability that the company is facing, particularly if there are punitive damages involved in the case, which there typically are in these scenarios. And then, of course, Maury mentioned before the risks of potentially having regulatory action or an SEC suit or some other type of law enforcement suit that you're going to have to deal with. And in these areas, oftentimes there are other people within the company who are experts in these areas, and so what's important is to get together, the people in the company who can sort of look at the bigger picture, think about what the broader risks are going to be to the company, including public relations issues, so that you can get a plan together for how to move forward. On the public relations front and the media front, it makes a lot of sense to figure out whether your position is going to be a reactive one or a proactive one, depending on the situation, and have a plan in place for, how you're going to deal with press releases related to the case or responses to media inquiry, sort of who is going to have to approve those sorts of things. I mean, all of these, as opposed to dealing with those issues on a fire drill basis when it comes up, it's good to get a jump on it by thinking about these things in advance. I think that moves us to slide 8.
Right. And I think a couple of additional points, Daphne, to follow up on what you said. There's an element of this early assessment, which is planning the strategy for down the road. And of course, as you mentioned, there's also an element of this early assessment that is dealing with the crisis management issues of the moment. If the litigation has come up, or if the issues have come up relatively suddenly, there are a checklist of items that need to be thought through at the company and addressed right away, including, as you mentioned, whether there are regulatory filings that need to be taken care of right away, whether there are press releases or public relations issues that need to be addressed right away, and, of course, at the very top of the list, whether there are safety issues that need to be addressed immediately, which might involve a plant closure or might involve a product recall, and those are obviously extremely difficult and complicated steps, and so getting in as quickly as possible to try to get your arms around the early sense of what the facts are, what the law is, allows you to do that. From the litigation strategy standpoint, it also allows you to think through some of the very first decisions that need to be made when you're facing multiple lawsuits, which would include what courts are you in? Are those the only courts that are your options? Are there possibilities to be in more favorable forums for the company? If you have cases in state courts, are they removable to federal court? Do you want to be in federal court? If you have a large number of cases in a particular state, do you want to try to coordinate those? Many states, including California, have proceedings, kind of a state equivalent of an MDL, to allow you to move multiple state cases into one location. Is that something that's going to be advantageous or disadvantageous to the company? And of course, on the federal side, is an MDL something that is available to the company and something that would be in the company's interest, and if so, where? And a lot of this sounds self-evident when we talk it through in a somewhat clinical way, but I think we've all seen situations where the problem arises relatively quickly. The company is in fire drill mode, as Daphne points out, and there's a tendency, just human nature-wise, to respond reactively and to not be as proactive as one can be in the very early stages of the lawsuit, which can make a huge difference, not just in the fire drill stage, but as the litigation goes forward.
This is Tom. One thing I would just add to everything that both Daphne and Maury have said, and if it was mentioned, I apologize for mentioning it again, but maybe it's worth it. In certain circumstances, and for some companies, another important component here is going to be risk management. Is this something that the company needs to notify its insurers about? Is there a problem that might create officer or director liability down the road? It's difficult to know. It's difficult to speak in generalities, rather, about something like that. But it's an important component to responding early on because, as we all know from having had to deal with risk management issues over the years, one of the first things the insurance company is going to ask is, were we provided a timely notice? So I think that looking at the risk management component of any large litigation, whether it's a single lawsuit or the prospect of, several hundred or even several thousand lawsuits, it's important to think about the risk management component of it very early on in the process.
And one additional point on this subject, which we shouldn't move along without discussing, is who conducts this early assessment. There are often occasions, and I think Daphne alluded to this, where the company already has existing relationships with outside counsel who are familiar with the business and who can easily step in and help do an early assessment. And remember, we're talking about an early evaluation before the company has really put together the full team that's going to handle all the litigation and all the regulatory proceedings, which we're going to be turning to in a few minutes. So in some circumstances, if there is an outside lawyer with whom the company, or an outside law firm with whom the company is already working, they're often a good candidate to come in because they know the business and they know the issues, even if that law firm may not be a lead law firm once the litigation proceeds. It's also possible for in-house counsel in some circumstances to do this early assessment as well, particularly in those circumstances where there is an in-house counsel who is familiar with the business, familiar with the issues, and can help very easily assess who the key employees are. If there are scientific issues, who are the key in-house scientific and medical personnel? Who is going to have the key documents? But whoever does it, whether it's inside or outside, I think what's very important, and this is going to address a question that we received about privilege. It's very important that, as in any internal investigation that you might conduct in another context, that the early assessment remains privileged, that it be done at the direction and under the control of a lawyer, whether that lawyer can be inside the company or outside the company, because you absolutely don't want to be in a position where you are creating memoranda or other materials that is potentially discoverable in the litigation. So it's very important that counsel direct the investigation, that any memoranda that are prepared by counsel at the direction of counsel with mental impressions, and that documents that are collected under the aegis or under the control of the lawyers as well. One final point, and then we'll move on to the next subject, and that is, at this stage, it's also very important that your checklist includes locking down all the important information. And that means suspending the company's document destruction policies, making sure that the IT department is aware that any routine destruction of email or other electronic documents gets suspended, and that servers are locked down, and as necessary, as you identify key employees, that individual employees' PCs or Blackberries or iPhones may need to be locked down as well. Not to suggest that the employees are going to do anything improper, but to help create the record, to help make sure that there are no inadvertent deletions of material, so that all of the material will be available as you move forward into the litigation. Daphne, Tom, unless you have something else, let's move on to slide 8, which talks about beginning to develop the strategy and beginning to identify the needs, and Tom's going to talk about that.
Yeah, once this crucial first assessment is done, initial assessment is done, and Daphne's exactly right, it's one of the biggest and most important pieces of this. But once that's done, and structures have been put in place, for example, document collection structures, and key employees have been reached out to and are being worked with to help them either prepare for deposition or work with them to glean as much information from them as possible. It's essential that the legal team sort of take a breath and begin to devise and communicate a clear and articulable strategy for moving the litigation forward. Obviously, this is a conversation that needs to take place with the most senior people within the company, not only legal staff, legal personnel, but also with business personnel, so that everyone is very clear on precisely what it is that we're trying to achieve through the litigation, and are prepared to, provide a consistent message to anyone working on the litigation, whether that's an in-house attorney or an outside counsel. And as the conversation goes forward about strategy, it's important to think in short, medium, and long term. Daphne made a very good point that during the initial assessment, you don't want to just think about the motion to dismiss. You want to be thinking about appellate issues. How do you preserve them, and how do you take those up to a court of appeals? And that's absolutely true as you're thinking about this strategy. You want to be thinking about what do we want to accomplish in the next month, 2 months, 3 months? What do we want to accomplish in the next 6 months or 9 months? And then what do we want to accomplish in the year? And obviously, things that impinge upon this are items such as the economic impact on business units. Is this how will this litigation economically affect business unit A, either in terms of the cost of taking people away from their jobs, or in terms of the cost of regulation, or in terms of some other cost that might accrue? What are the costs of litigation? Is this a case that can conceivably be tried in one location, still applying significant resources but not having the geographic spread? Or is this a case that's going to be taking people all over the country, and what impact will that have on costs? What's the likelihood of local, state, or federal government involvement? And indeed, beyond just the government of the United States, what's the likelihood that this may spread to other jurisdictions outside the United States, and the possibility that other governments might become involved? And then, of course, what's the possibility of regulation here? How will, even if the government doesn't get involved as a party to the litigation, what might the government response be? Some form of regulation that would either shut a business down or constrain its ability to operate. Maury mentioned something that I think is also important about the sort of reflexive nature sometimes of response to litigation, and I think that it's been my experience that oftentimes companies that are threatened with large litigation kind of hunker down and take a very defensive posture and kind of pull in all of their feelers and protect themselves, and in some circumstances that's certainly warranted, but it's important to think about it and not allow it just to be a reflex. It's important to consider whether or not being aggressive and going out and filing an early and aggressive motion to dismiss might not be the best way to deal with a particular piece of litigation. And frankly, again, it's been my experience that in some cases it's up to the legal team, including the in-house lawyers, to convince the business people that being more aggressive and applying resources early in the case might be a better strategy than simply hunkering down and waiting for smart plaintiffs' lawyers to begin lobbing grenades over the wall. A couple of other sort of decision drivers as you're thinking about strategy that are important. Do you know the universe of claims that are being brought? Is it possible to essentially draw a circle around the claims so that you can say, look, we know that because of a statute of limitations issue or because of a marketing issue or whatever it might be, we can comfortably predict that there are going to be 1,000 claims. If that's true, if you can draw that circle, then it may be possible to see the risk of litigation in relation to the cost of litigation. And that may push you in one direction, perhaps towards trying to get an early settlement. But what if the universe of claims is unknown? What if there's a long statute of limitations? There are all kinds of plaintiffs' lawyers out there putting ads up on during the $1 million movie at midnight, saying, if you've been injured, call me. That might be that might push you in a very different direction, because it's difficult to balance, or weigh rather, the risks of litigation against the cost. Another driver: are some claims against you stronger than others? Is this a situation in which there may actually be some valid claims out there that pose a significant threat in the form of liability to the company? On the other hand, there are claims out there that are very weak and are being brought simply by someone trying to make a quick buck, and that may push you in any number of different directions, or push the strategy in any number of different directions, including a desire to try to separate wheat from chaff, maybe push certain claims more aggressively in order to get some low or defense verdicts on the books to kind of drive the price of a settlement down. It may also push you towards some bellwether trials, and that's certainly something to consider as you're thinking about a strategy. And of course, bellwether trials also have a value in them, in that it allows the decision makers, whether they're business people or lawyers, to better comprehend the universe of the risk. Obviously, if you've tried 3 or 4 cases and gotten all defense verdicts, that tells you one thing. If you've gotten all plaintiff's verdicts with large dollars, that tells you something else. And of course, a bellwether trial does have the possibility of an exposure to liability. But the outcome of the conversation about strategy should really guide the decision making about the 5 bullet points that you see on slide 8 there. The bottom line is, as you put all of these things into the hopper, and as you talk them through with the senior business folks, with the senior lawyers in-house, and with your outside counsel, the how you resolve these points should hopefully become clear, and that's why the strategy part is so critical. And I think one last point here is that communicating the strategy is really essential. Outside attorneys, as well as in-house folks, are going to react to whatever comes up in the course of litigation based on how well you're able to communicate your strategy about moving this case forward. So if everybody understands that we are going to take these cases through trial, then getting an adverse decision is not going to come as quite the surprise it might if some people didn't understand that, and thought that gee, I thought we were just going to try to settle these things. So making sure that you communicate that strategy, I think, is very important. Making sure that it's clear, and of course, the strategy needs to evolve. And as the strategy evolves, as new things come up, new decisions are rendered, whether they're decisions in your case or decisions in other cases that have an impact on your case, the strategy needs to evolve. And as it evolves, that fact needs to be communicated as well.
Yeah, and as before we move on to the next slide, Tom, just to emphasize that point, one thing that we've seen in a number of situations, sometimes dealing with very sophisticated clients, that the non-lawyer executives and decision makers in the company may have one view of the litigation, which is simply, this is going to be expensive, how quickly can we make it go away? Or there is sometimes a different kind of reaction, which is, how dare they bring these lawsuits? These are all frivolous. We need to fight them. And those are often good instincts, but not always. And one of the challenges that in-house lawyers, I know, face is developing a consensus inside the company on what the bigger picture is, what the legal strategy needs to be, and how the legal strategy aligns with what the company is trying to accomplish, which, as Tom points out, can be very different in very different cases. And an advantage to having, as best you can, your arms around the situation very early on empowers both the in-house lawyers with the assistance of outside counsel in sitting down with management, explaining the process, explaining the risks, and developing a strategy that will have buy-in as litigation proceeds, particularly if the litigation is going to turn out to be protracted and expensive.
Yeah, I mean, I would second that for sure, making sure that everybody in-house is on the same page. But one comment I would make is when you're right that you have to have, especially the high-level decision makers have to all be on the same page with regard to what your strategy is going to be. But I think if you're talking about a mass tort like this, most oftentimes what you're going to have is sort of two tracks, right? You're going to have one track of litigation where things are progressing, cases are being discovered, you're having battles about discovery, cases are getting ready for trial, and then there probably oftentimes will be the settlement, people thinking about settlement sort of on a separate track. And it's important, I think, for purposes of outside counsel sometimes to keep those two things separate, because once people start thinking settlement on the litigation side, they tend to not focus as much as maybe they should on developing the cases and getting them ready for trial. I mean, a lot of people are able to hold those two competing thoughts in their head at the same time, but sometimes it does make it a little difficult. So I think it's important that the high-level decision makers all be on the same page, and then you have to make decisions about sort of what information trickles down and how far it trickles down in order to make sure that the folks who are on the ground working are keeping their eye on the ball.
Yeah, that's a great comment and exactly right, and it may be a segue into our next slide about the legal team, because one of the things that I wanted to mention here, and it bears directly on what Daphne was just saying, is that oftentimes you do want to have a group of senior people that are obviously aware of all the parts of this problem, all the parts of this litigation, but then maybe two cones, two groups of people reporting up to that senior team. One of them would be, your litigation team, the folks who are responsible for working up the cases, and the other group, perhaps a much smaller group, perhaps a so-called virtual law firm or a blended group of senior folks from a number of different firms who are thinking in a kind of a grand strategic way about what the end game is, how cases will ultimately be settled. And I've certainly been involved in a number of cases that have worked that way for precisely the reasons that Daphne just articulated. I think once the litigators, the folks who are really have the bit in their teeth and are moving the case forward towards trial and have been charged with preparing these cases and defending the company, once they begin to hear, discussion of settlement, that does tend to take a little wind out of their sails. That's a difficult thing it's difficult to hold in your head, the idea of, this case is going to settle, but I got to push really hard. It's not easy to do. And frankly, litigating because you're in the trenches, because you're dealing with plaintiffs' lawyers, because you're dealing with folks who obviously are trying to do what's best for their client, which is contrary to what's best for your client. It creates tensions as well that may get in the way of seeing a path towards settlement. So I completely agree with Daphne on the idea of a settlement team versus a trial team, but the point that a couple of things I want to say related to this next slide is that once you've got the strategy, once you've developed it and you've made some decisions about how you're going to proceed, you can begin to put your legal case together. And obviously, there are lots of factors that affect this. We've talked about some of them, what jurisdiction you're in, and I want to take just a moment to talk about that. There are a number of jurisdictions around the country that have, very restrictive regulations on the bar. That is going to have a significant impact on how you structure your legal team. it may be very important to have counsel in that jurisdiction who can not only serve as a mail drop or something like that, as sometimes local counsel are used, but also perhaps be the person who's going to stand up in court and argue motions and try cases and so forth. And so you need to know, will the XYZ state allow my favorite trial lawyer from Chicago or Denver or Los Angeles to, walk into the courthouse and try the case for me, or am I going to have to, do something different? So it's important to pay attention to the jurisdiction early on as you're beginning to assemble the team. If you have a large case in a single jurisdiction, it may make sense to issue an RFP and hire one firm to do everything. That's a pretty easy case. The much harder case, of course, is the case where you have claims filed across many jurisdictions. It may be across multiple states, but it could also be across a very large a single state. If you've got a lot of cases filed across the state of Rhode Island, that may be easier to deal with than if you have a lot of cases filed across the state of California. And you need to look, as Maury said, at procedural vehicles like an MDL process that might allow you to bring them all into a single courthouse. But it's also important as you're looking at this large case to think about the skills that you're going to need to defend the company. Is it going to be a document-intensive case? Is it going to be a case where there are going to be many, many witnesses called from the company or from the plaintiffs? And you need to start breaking down tasks and beginning to think about, we need to collect documents. We need to code documents. We need to review documents. We need to create privilege logs. We need to identify witnesses. We need to identify experts. And all of those things are important and essential questions to ask as you're beginning to pull the team together. As you do this, of course, you're going to make some choices about where to invest. If the case is definitely going to go to trial, you're probably going to want to invest in the best trial counsel that you have available to you. If the case is going to, if you think that the best strategy is to pursue an early settlement, you're going to want to invest in your settlement team and make sure that that you have the best folks advising you on that. The bottom line for assembling the team, I think, is particularly is looking for the skills that you need, but in addition to that, looking for the ability to communicate, particularly across law firms, if you're going to go the virtual law firm route. And experience working in that context is going to be very important and something that you're going to want to focus on, because I think that the ability to have that type of communication and set up clear lines, not only of responsibility but of reporting through various law firms up into the team that's considering strategy is going to be essential to the long-term goal, which is going to be effectively and efficiently and cost-effectively litigating the case.
The last 2 points that Tom's been talking about aligning the strategies and identifying the skills, as Tom pointed out and as we've all commented, involve keeping a lot of balls in the air at the same time. And what makes it more complicated are those situations where, in addition to lots of individual lawsuits and lots of potential class actions, there are also parallel proceedings, as we referred to earlier, with government investigations, regulatory issues as well. And, that's one reason why, as we've all pointed out, the strategy has to evolve over time, although it's always best to have the goals in mind and at least an initial assessment of where the strategy is going at the beginning. There are times when, particularly when a government regulatory agency is involved or law enforcement is involved, the company has even less control over the timing and the sequence than it would have in lots of other situations. And there are times in which it will be necessary to put the regulatory concerns or the law enforcement concerns first, there will be times when obviously resolving those has an impact on how the litigation proceeds. And that's why in putting together the team, it's important to have the pieces in place, the specialized skills necessary to address each issue, and a structure in place so that the proper decisions and revisions to the strategy can be made as you move forward. And I think that brings us to figuring out the teams both in-house and outside and how that's structured. And I think that's particularly something where Daphne, as an in-house person, is going to have a lot of terrific perspective. From an outside lawyer's perspective, Tom and I wish we lived in a world where the answer was you place one call to Arnold and Porter and then the client is done. But unfortunately, we don't live in that world. And we live in a world where a client has a lot of options and a lot of ability to put together teams that use the best skills and the best cost management from lots of different sources. So, Daphne, if you wouldn't mind picking up on the next slide to slide 10.
Yeah, sure. I mean, in terms of in-house, I know there are a lot of in-house folks on the phone, and, a very important thing is figuring out in-house who's responsible for what, and developing very clear lines of responsibility for cases. I mean, when you have a mass tort like this, typically, one person may not manage the entire thing. You may split it up. It may be that you have one in-house lawyer who deals with, particular jurisdictions and another who deals with another, or one in-house lawyer who deals with certain procedural aspects of the case, like all the pretrial, and someone else who deals with trial, and maybe someone else who deals with appeal. So you can split it up based on the type of work, or you can split it up based on geography. But however you do it, or it may be that one person is in charge of it, but however you do it, there needs to be, clear lines of responsibility, and you need to know early on, who needs to know what from me. If you're the person managing the case, what is it that you need to share, and who do you need to share that with, and on what sort of a time frame. So setting those expectations is a very important, I think, part of the case, because once you've set them and you've told, your general counsel, you're going to get a report every Friday on where we are, then, that's what happens unless something unusual occurs and you have to give, a special report. But setting up, regular reporting to both, your boss within the law department, and even beyond that, to the business, and how regularly you're going to do that, is critical, because the people who are the decision makers need to have the information. They need to not be surprised by particular developments, and so sort of setting people's expectations, both for when they're going to get the reports, but also for what's going to probably happen in the case and what it's going to look like, is important. And then communicating consistently along the lines you set up. That way, nobody's surprised. Everybody knows what's going on, or at least the people who need to know what's going on know what's going on. And the people you need for input on decisions, have the information that they need in advance, and so are able to make decisions much more quickly. So those kinds of reporting are important. And, it varies. It's going to vary depending on the type of case and how much activity there is. If you're in a trial, you may have daily reports on what's happening in that trial. If there are no trials going on, maybe there are weekly reports about developments in the litigation. And you also need to figure out whether the reporting is going to be oral or written, and make decisions about that. But the most important thing, I think, is setting expectations and figuring out what the lines of responsibility are and who's going to be told what. And once you do that and you've got the procedure in place, things flow much more smoothly. On the hiring the team point, as Maury pointed out, nowadays most companies are using multiple law firms. We're kind of past the days where a company hires one firm to handle all of their legal needs. And even beyond that, because you may hire multiple firms, one for corporate, one for litigation, but even on the litigation side, you're hiring multiple firms to do different types of activities within the world of litigation. And, one piece of advice I would give to folks is to think in advance about who it is you would call if you have a problem like this. And it may vary. It's going to depend. Is it a class action? Is it that you have some kind of SEC action? Is it a bunch of individual lawsuits that are filed? I mean, it may vary depending on the type of case, but you should have in your mind, the top 3 people you would think about calling if you ever are faced with this situation, because you want to be able to make that phone call quickly, and you want to be able to talk to someone, a quote, trusted advisor very quickly about the situation that you're facing, because you're going to want to be able to give answers to your general counsel or your business people as quickly as possible, and you're going to be able to do that more comfortably if you've got an outside lawyer who you trust advising you early on. So I would say think about in advance who you would call when you have this type of situation. But then in terms of who, in this world we live in, lawyers specialize. And so for most mass tort cases, you're going to want to hire a firm, and also lawyers cost differing amounts. And if you're going to have a huge amount of discovery that's going to have to take place on thousands of cases, then you want to do it in a cost-efficient way, an economical way, and so you may want to look at a firm that's not as expensive for that type of work. Very good, of course, but not as expensive. If you're looking at a situation where you think you've got a very novel legal issue that's going to go up to the U.S. Supreme Court, then you also want to look at hiring, the very best and brightest legal brief writer, an appellate type lawyer. And so you probably are going to be looking for a variety of different types of lawyers to form a team to handle whatever the case is. So I think you need to, rarely does any company use one firm to handle a case, unless it's, like as Tom mentioned, a single case in a single jurisdiction, and, that's a very different situation. But you're going to want to compile a team. Most of us hire lawyers these days, not firms. Lawyers have certain reputations and are good at particular things that they do, and they happen to be at different firms. But nowadays, they all work very well together, and so I think you're going to put together a team of good lawyers from whichever firms they're from, thinking about, what tasks you're going to ask them to do and what their rates are. And of course, depending on the geography, you may well need local counsel. You may well need a lot of local counsel in a particular state, depending on how many cases there are and that sort of thing. The other thing to think about, and Tom touched on this when he talked about trial counsel, but, if you're going to be trying cases, you need to think early on about getting your trial lawyers involved. And you may not know which case is going to go to trial first. You may not know what kind of court it's going to be, or whether it's going to be state or federal, whether it's going to be in the South or in the Northeast. But you should think about hiring multiple trial counsel who you think are very good, who may well fit for wherever your first case is going to be, and getting them involved early. It may be that it's the kind of case where you're really going to want a woman to be your trial lawyer, and so you should look at finding a great woman trial lawyer. It may well be that you think it's going to be in Texas, so maybe you're going to look for a Texas trial lawyer. But getting the trial lawyers involved relatively early on to guide the discovery strategy and how the themes of the cases are worked up is usually well worth the money. Trial lawyers can be expensive, and it can cost a little extra to have them thinking about the case from such an early stage. But at the end of the day, it's worth it because they know how they want to try the case. They know what's going to sell to a jury if it ends up being a jury trial, and they can direct, the depositions and some of the document work, whatever it is, so that the case is developed in a way that first bellwether trial, if you're trying a handful of cases, is really worked up the way you need it to be worked up, so you can get the best result. So I would put in a plug for thinking about your trial lawyers in advance. And like I said, you may not know exactly who's going to try the case because you don't know where it's going to be, but if you get a handful of trial lawyers together, probably one of them will fit, and they can help guide the strategy. In terms of, I sort of touched on this division of responsibility. It really, there are all these different tasks that we talked about. Oftentimes, you have a whole team that just focuses on expert witnesses. There may be medical expert witnesses. There could be experts related to liability. If it's a pharmaceutical case, you've got your FDA experts. There are all sorts of different experts, and you typically want, a group of people to focus on particular areas because it's going to be, there's a lot of sort of learning that has to be done to prepare very technical expert witnesses, and so you want a team that's focused on that. Typically, you want a team that's focused on the fact discovery and a team that's focused on the legal issues. And in terms of legal, as I mentioned before, I think it's well worth it to put together a multi-firm team of legal folks who think about the case from the day it's filed all the way through the appeal. And those people deal with all the pretrial motions, summary judgments, motions in limine. They deal with the legal issues at trial, with the jury instructions, with the verdict form, and they're thinking about all of those things in a cohesive way, particularly in the lens of what are we going to argue on appeal. Because, oftentimes you end up on appeal and certain issues haven't been preserved properly, or the jury instructions didn't ask for the particular instruction that you needed. And so having a core legal team from the very beginning that's going to follow the legal issues all the way through to the end is really worth its investment, I think. So that's what some of the factors I would think about in terms of, who to hire. I just think it's almost doesn't exist anymore that you have one firm that does everything. You have to really think about who it is that's best for a particular task, then think about the lawyer, the individual who would be best to do it, and then I think law firm is, law firm's important, but it's not the key item to think about.
Which brings us to the next subject, which is budgeting this. As you all know, complex, time-consuming, lengthy litigation like this with lots of lawsuits and potential other proceedings is expensive. As I mentioned, it's very time-consuming, and in some degree, it is unpredictable. But that doesn't mean that there aren't ways to manage the costs, to manage the team, to control the budget and control the spend so that you don't get into horrible trouble with the people in your company. And we want to talk about some of the ways that we have found over time and worked with clients and other lawyers over time to do. We're not going to spend a lot of time weighing the upsides and the downsides of the billable hour versus fixed fees versus blended rates versus incentive payments. Each has its pluses and minuses. Different clients have different preferences, and I know different lawyers, outside lawyers, have different preferences. They all have the capacity to create inefficiencies. They all have the capacity to be very efficient as well. So what we'd like to focus on is really more what I guess we'd call the functional component of the budget, which is viewing the budget as part and parcel of your strategy and using that as a way to do your best to control the costs. For example, Daphne talked about paying rates for lawyers commensurate with the tasks they're going to perform. You're going to pay more money, obviously, for a brand name trial lawyer than you're going to pay for the person who is reviewing the documents. And that's important in terms of tasks, and it's also important in terms of geography. If you are in a litigation where a number of plaintiffs live in, say, Montana, and you'll have to do individual discovery of a number of plaintiffs in Montana, you might be best served having strong Montana counsel that can do that work for you and do it most likely at less rates than your lawyers from New York, Chicago, Washington or Los Angeles. That goes for court appearances as well, not just in cutting down on travel expenses, but having lawyers who not only substantively know the court, but can handle the routine court appearances, the day-to-day court appearances most effectively. Even if you are using a large law firm to coordinate the case, then the client, you, should spend some time making sure those lawyers are budgeting their tasks efficiently. If they're going to be using contract lawyers to review the company's documents, to look for documents that need to be turned over in discovery or documents that will be necessary to build the company's case, or both, how is that going to be structured from a cost standpoint? And even more importantly, how is it going to be managed so that it's done efficiently, so that the contract lawyers are doing the work that lawyers at lower fees should be doing, but they are being effectively supervised by lawyers in the firm or more senior lawyers to make sure that the document review is not duplicative, it's not wasteful in terms of time. Similarly, an issue in creating your best budget is figuring out how much a matter costs and how effectively you can get there. And what I mean by that is most clients, well, most law firms and many clients are getting better, particularly clients who have dealt with lots of litigation over time, are getting more and more sophisticated and have more and more experience data on how much generally things can cost. How much it costs to prepare a motion to dismiss. Even though there can be great variation among cases and even variation within a case, I think there's a much greater pool of data than we had 5, 10, 15 years ago on what the expectations are of what a matter should cost. How the client and the law firm end up working that out in terms of a budget, as I said before, by way of a certain type of fee arrangement or different, should be in a sense only part of the piece, because however you are going to pay the lawyer by the hour, by the task, you should be paying for a motion to dismiss what it costs to write and research a motion to dismiss. And I think developing that kind of experience data for a client and developing that kind of experience data within a law firm is sometimes a daunting task, but we found that it's very effective in being able to predict, as you're preparing the budget, how much the task should cost and what the client's expectation should be. There's also an ability, thinking of your budget as part of your strategy, to sequence certain matters within the litigation and have those have a favorable impact on the budget. What I mean by that is, if you have a large number of cases, let's suppose there are a large number of individual cases scattered about in state courts or in federal courts or both around the country, it's not practical and it's certainly not cost effective to work them all up simultaneously. It may be effective to work up certain cases and to work out an agreement with the plaintiff's lawyers fairly early on in the litigation about how individual cases are going to be sequenced. That's something that is often in the advantage of both the defense and the plaintiffs, to manage the litigation in an effective way, to not spin wheels, to not waste money, and to time cases so that it's clear to both sides the order in which cases are going to move forward, which cases are going to be moving to trial, and which cases can be put on the back burner for a while. There are obviously strategic issues involved in how those cases might be selected, and there will be no doubt jockeying between the plaintiffs and the defense on how to sequence cases and how to select cases. But from a budgetary standpoint, that's something that can be effective for all parties in the litigation. And it's also effective, speaking of experience data, as some of those cases move forward, the company, as well as the plaintiffs, I suppose, will develop much greater expertise of the kind of work that needs to be done. And this is a point that's often overlooked, and it's often overlooked in complex litigation, where there is a temptation, and there has been historically, to do everything, to leave no stone unturned. There may be cases where that's necessary. There may be parts of cases where that's necessary. But there may also be cases or parts of cases where an assessment can be made fairly early that it's not necessary to do everything. If you have a large number of individual plaintiffs moving forward, you may decide that 20 depositions are necessary. You may decide that 20 depositions per case are necessary for the first few cases, but then you only need 10 or 8. You can also develop teams of lawyers who develop expertise in particular kinds of depositions, particular kinds of discovery, so that you can create more efficiencies that way. So that you can, looking over time, find ways to sequence discovery. You can find ways to make intelligent decisions about balancing risk versus efficiency in what work needs to be done and what work doesn't need to be done. Another area similar to that, where sequencing decisions can be very important, is when you have a sense, as we've been talking about throughout this presentation, about what issues are going to drive the case, what issues are going to be potentially dispositive. You may decide, because it's helpful both strategically and from your budget perspective, to sequence those issues at particular times in the case where it's most advantageous for you. If you think you have a dispositive issue, to take a very simplistic thing that we do in a simple case, but can be applied in context in much more complicated litigation, if you think you've got a statute of limitations issue that might drive your case, you might try to litigate that up front and position that for a motion fairly early on as a way to dispose of the case, and dispose of the case at a much lower budget number than if you had to litigate everything. It's a straightforward principle, but the principle can also be applied in cases where there are many more issues, where the issues are much more complex, and you can develop a sense fairly early on of what are issues that might drive this. What are issues, Daphne and Tom both talked about having a sense early on of what the appellate issues might be. If you think there are appellate issues that might drive your litigation, how do you get those litigated promptly and get them up on appeal as rapidly as you can, because that may have an impact on how the rest of the litigation is going to, how much the rest of the litigation is going to cost. So those are some examples of how you can use the strategy that you've developed, make calculated risks of where you want to spend your money, where you can save your money, and budget your litigation in a way that it is more cost effective. One final point. I'm sorry, go ahead, Daphne.
Yeah, I was going to add a point. This is sort of more on the mundane side, but if if you have a whole bunch of cases that are being worked up, which is, typically the situation you're in when you have a mass tort like this, there are other sorts of guidelines you can put in place for your outside counsel to try to reduce costs. It may be that the first few of these cases you don't want to you don't want to really put limits because you want them to be developed as thoroughly as possible. But once you've gotten beyond that point and you're working up a lot of cases that, more than likely will not go to trial, the question is, are there ways to do things more efficiently? One way Maury alluded to is to have particular teams who deal with particular issues. And the reason that's useful is you can require, for example, the expert team. Only people from the expert team can take expert depositions. It's going to take those folks a whole lot less time to get ready to take an expert deposition than it will someone who's not on that team, who doesn't already have that sort of core base level of knowledge. You can also, develop limits for who attends depositions. Is it only the lawyer who's actually taking the deposition? Who attends expert meetings? Whether meetings should be in person or on the phone. Traveling is very expensive, but you can usually talk to a lot of experts on the phone, and you don't necessarily need to fly to get there. There's also video conferencing, and you can put sort of hours based limits in place on the number of hours you're going to pay for someone to prepare for a particular type of deposition. And some of these things, there need to be exceptions. There's always exceptions to the rule, but some of these kind of basic rules can end up saving you a lot of money. And if you don't have them in place, and the firms can sort of run willy-nilly and do these things how they want, they may, or more likely than not, it's going to cost you more than if you put these sorts of rules in place and then ask them to ask you for an exception if they need one. And there often will be reasons for that, but I think the base guidelines can often save you a lot of money and help you manage the budget as well.
Yeah, and this is Tom. I think that that's exactly right. I mean, it also creates predictability for outside counsel. It allows your outside firm to better, budget their own resources and be able to provide you as an in-house attorney facing this kind of challenge greater certainty with respect to what cost is going to be. So if you can, as Daphne suggested, work up a few cases fully and then get your strategic team together to think, okay, do we really need to take the deposition of the second cousin, or can we get by if we only take the deposition of the plaintiff and her sisters or something like that? And then communicate that clearly to outside counsel. That gives outside counsel the ability to provide you with a budget that's more certain in terms of resources expended. Pardon me. And this kind of goes into the next slide, I think, slide 13, talking about management, because one of the things that I think is important, and I'm not going to spend a lot of time on this. I know we're beginning to run short on time. But one of the things that you've heard all of us say is the importance of identifying tasks and creating teams to deal with this. That is, and that's right, but it creates the possibility for, sort of this juggernaut that just runs amok on your legal budget. And I think that the most important thing, the hallmark of successful management of a litigation team like this, is communication. How do you make sure that the team that is taking expert depositions is communicating with the team that is taking the depositions of fact witnesses, so that they know what the plaintiff's expert is looking at, and the information the plaintiff's expert is receiving, even before they get a disclosure under the federal or state rules. And that communication, I think, is essential, and many of the other points here sort of speak for themselves. But I will say something about the importance of having regular conference calls, if nothing else, between and among various teams, so that they do know what each other are doing. And that's also not just important among the teams that are working on discovery, but also teams that are working on issues like motions practice and legal issues. I've been involved in a number of cases over the years where a new legal theory is developed after one or two cases have been tried, and as the theory is developed, it becomes more apparent that it's really very solid, and you need to get that information out to the people who are doing the discovery so that they can point their depositions, point their paper discovery and so forth in the direction of eliciting responses that will be supportive of this legal theory. And the best and only way you can do that is by communicating with folks regularly. So setting up weekly conference calls, making sure that people make it a priority to participate in those calls, and this goes double if you have litigation where you're one of several co-defendants. Involving your co-defendants to the extent you can, it's practicable to do that in these calls is also critical, so that you've got a coordinated strategy where it's not a single company that's working particularly well and efficiently, only to be undermined by a co-defendant that's not doing what it needs to do. That communication, I think, is critical. There's lots that can be said about each one of these bullet points here, and as I said, I won't go into them in great depth. I will say one last thing about trial management. I think one of the most difficult and complex things is managing litigation where you've got multiple trials going on at the same time. Because obviously you can't afford to have a trial lawyer in, courthouse A saying something about your product or your process that is contradicted by what the trial lawyer in courthouse B is saying. And again, that is all about communication, making sure that the management, the strategic management, gets daily reports about what's happening in trial, understanding how the trial is unfolding, having someone scour transcripts to make sure that people remain consistent, as well as for affirmative purposes of figuring out what the plaintiffs are doing and how their theories and strategies are evolving are really critical here. It's not an inexpensive solution, but ignoring it really creates a significant risk that you're going to be whipsawed by a clever plaintiff's lawyer who is looking at transcripts, and they're going to argue to a judge, well, yesterday in the courthouse up the road they said this, and now they're down here saying that, and both can't be true. So that's it for those are my thoughts, at least on slide 13.
Thanks. And one additional point on budgeting and management, which has to do with predictability of the budget. Obviously, when a client comes in at the very beginning of what can be very long and complicated mass tort litigation and says, how much is this going to cost from soup to nuts, all the blood rushes from my head because it's a very, very difficult thing to predict looking out 2, 3, 4, sometimes years. Although we have experience data, we do the best we can. But what I think works very well as the litigation moves forward, we know that you as in-house lawyers have to provide often annual budgets, and they have to be broken down into quarters. And while it's hard to predict exactly what's going to be happening in a litigation 9 months down the road, it's not that difficult to predict if you've got a good management structure set up and a good strategy in place. It's not that difficult to predict what's going to be happening 60 or 90 days down the road. And what I found has worked well with a lot of clients and they found very helpful in their budgeting process is to have a monthly checkup on the budget for the upcoming quarter, which of course will change as you learn things and as things happen during the course of a month or of a quarter. But we should be able to predict fairly accurately what's going to happen in the next quarter and adjust the budget accordingly so that the in-house lawyers are able to have a fairly accurate budget for the company, and it minimizes the possibility of surprises for you, the in-house lawyers, or for the people you are reporting to. And what I found often works is as you're preparing the monthly bill, you just take that moment to look ahead at what you've got on the budget coming up and what you've got coming down the pike in the litigation and make sure that those remain in alignment every month. And that's another, I think, tool if you've got a good strategy in place that can work. I know we're running a little short on time, and Daphne, I wanted to give you just a minute to talk about the role of in-house counsel in day-to-day management, and it's really a question of how much can you do and how much do you need to rely on outside lawyers to help you make the trains run with so many moving pieces.
Right. And, this is a really tough question. I think it varies significantly depending on the culture of your company and also depending on, individual sort of styles. And it depends greatly on how comfortable you are with the outside counsel that you have running the case for you. So in terms of, how you manage, or I should say how much you micromanage the litigation, all of those things come into play. But at a very basic level, I would say, one of the key jobs of in-house counsel is to make sure that your outside counsel teams are cross-fertilizing and sharing information. And you can do that in a variety of ways. Tom mentioned conference calls. Also, I think requiring trainings for lawyers who are going to be taking depositions in a case, maybe training for fact-type discovery and then a training on expert discovery. Requiring those to happen forces people to communicate and to get on the same page, and I think it's important for in-house counsel to trigger those types of trainings. It's also important, I think, to have regular sort of lessons learned meetings. So after you've had a few trials, bringing all of your trial counsel together and having them talk about what worked, what didn't work in their cases. I do think that is something in-house counsel should require of their trial lawyers, and it's something that at the end of the day, makes everybody better at what they do. And so, it's kind of hard to pinpoint how involved you need to be in the day-to-day stuff. I do think you have to hire people who you fully trust, and then you've got to let go and let them do their jobs. That's what they're good at. That's what you hired them to do. But you can't let go completely. I think in-house counsel certainly needs to stay involved to keep everybody coordinated and to make sure that information gets shared across the teams. So those are my comments on that.
Thanks. And I know we're getting towards the end of our time together, and thank you all for participating. There's one question that came over that I need to ask you, Daphne, which is, the question is, when dealing with the high-profile trial lawyers and specialists in various fields, how do you manage all the egos?
Sometimes it's surprising to me. Some of the high-profile trial lawyers do not have any ego whatsoever, and then others, of course, have quite big ones. But at the end of the day, it's mostly knowing the case as well as they do. Often, sort of gives you a certain command, and so I think, it's experience, it's knowing the case, and then it's understanding that, at the end of the day, the goal is to win the case, and most high-profile trial lawyers really want to win the case, and so they're going to work well with anyone they think is going to help them in that regard. I haven't found egos to be unmanageable for the most part.
Thanks. Thanks to Daphne, and thanks to Tom, and thanks to all of you for participating. We appreciate you spending the time with us. I believe you'll be sent the materials after the conclusion of the webinar. Arnold & Porter is going to have another webinar, the next in the series, on defending mass tort litigation and class actions. It's going to be on October 12, and it's going to be about presenting and developing the company's story, as you see laid out on the slide that's before you. We think it's going to be a very interesting program. We hope you'll join us. Please tell your colleagues about it. Please tell your Facebook friends, and we hope you'll be able to join us then. So thanks very much to everybody for participating today, and have a great afternoon. Class action treatment where there are personal injuries. There may be separate claims or separate cases for purely economic injuries, which might well be brought in individual or multiple class actions. In this type of litigation, the plaintiff's lawyers tend to be reasonably well organized, sometimes before the litigation is even filed, but frequently as they work together as the litigation proceeds. And they are almost always very well funded. And the company may face not just these civil lawsuits brought by individual plaintiffs, but proceedings brought by regulators at the federal level in the United States, sometimes regulatory issues from other countries. There might be regulatory issues brought by state regulators. As many of you know, in recent years, state attorneys general have become much more active in pursuing issues related to mass tort, products kinds of cases, and other things that used to be left to the federal government and the civil bar. And of course, there are also the possibilities of proceedings by the Securities and Exchange Commission, private actions brought by the company's shareholders, and in some instances the possibility of criminal investigations either at the federal or at the state level. You know, when these kinds of lawsuits arrive, they're characterized by some fairly common factors, which is going to be the basis for some of the management and organizational and strategic concerns we're going to talk about today. It's almost always the case that in order to produce discovery and prepare the company's defense and tell the company's story, there are large numbers of documents, both paper and electronic, to be gathered, reviewed, coded, and made accessible. There are company witnesses, often large numbers of company witnesses, to be prepared for their testimony and to be interviewed to help build the company's case. Particularly where there are personal injury cases, which may be scattered about the country, there are large numbers of individual plaintiffs whose cases need to be discovered and litigated individually and in many cases simultaneously. And that involves collecting documents from each of them, developing and deposing fact witnesses in each of those cases, and exploring and developing medical and scientific defenses as appropriate in each of those cases. And going to be available to join us, and she sends along her apologies. We have a relatively small number of slides which we'll share with you, which we hope will introduce the topics we're going to talk about with our panel of in-house and outside lawyers. And we're hoping we can offer some varied perspectives on some of these issues. As you heard, the lines for our participants are muted. So if you have any questions, please use the chat feature tool within WebEx and send any questions to the host. We will try to get to as many of the questions as we can towards the end of our time together as time permits. And of course, if we don't get to your questions or you have questions later, feel free to contact any of us offline at your convenience. If you need any assistance during the webinar, please press *0 and somebody will be available to assist you. We are recording this event and we are going to post it on the Arnold & Porter website, where it will be available to the public and to you if you would like to listen to it again and again. Let's begin. The kind of cases that we're going to talk about today that raise the organization and management issues that we're focusing on could involve any number of substantive areas. But we're going to focus today conceptually on mass tort and product liability cases that involve consumer products or pharmaceuticals or medical devices, or the kind of environmental exposures that can lead to significant legal issues in a variety of fora for a company. And of course, the legal issues involve many of the items that you see on this slide 4. There are often personal injury cases that, depending on the nature of the litigation, could be confined to a single state, or they could be in state and federal courts throughout the country. If there are personal injury actions, there may be a large number of individual cases. It's not uncommon in litigation such as this for there to be thousands of cases. Or the plaintiff's lawyers may try to aggregate individual cases into group actions, which we see in a number of types of these cases where multiple plaintiffs sue in one group lawsuit. We've also seen plaintiffs' lawyers try to bring personal injury claims as a class action, although those are usually inappropriate types of cases for.
Good day, ladies and gentlemen, and welcome to the Setting the Goals, Building the Team, Managing the Budget webcast. My name is Fab, and I'll be your operator for today. At this time, all participants are in listen-only mode. If at any time you require operator assistance, please press star followed by 0, and we will be happy to assist you. I would now like to turn the conference over to your host for today, Mr. Maury Leiter. Please proceed.
Thanks, and good afternoon, everybody, and welcome to our webinar on defending mass tort litigation and class actions. Today we're going to talk about some aspects of managing different types of complex litigation. And today, as you know, we're focusing on setting the goals, building the team, and managing the budget. I'm Maury Leiter. I'm a partner at Arnold & Porter in Los Angeles. I'm a litigator handling complex litigation and trials in mass tort, product liability, and other commercial cases. I've been here at Arnold & Porter for 21 years. Before that, I spent several years at the U.S. Attorney's Office in Los Angeles handling white-collar criminal prosecutions. Also with us is Daphne O'Connor. Daphne?
Yes, hello, Daphne O'Connor. I am Vice President and Associate General Counsel at Altria Client Services. I've been here for 4 years, where I manage commercial and product liability litigation, which includes mass torts, appeals, trials, the gambit of litigation. Before that, I was at Arnold & Porter for 14 years in both the D.C. and the Denver offices, where I did mostly pharmaceutical work and product liability work as an outside counsel.
And Tom Stover.
Good afternoon. My name is Tom Stover. I'm a partner in Arnold & Porter's Denver office. I've been practicing with the firm now for about 17 years. The bulk of that time has been spent defending the firm's clients in mass tort and product liability litigation around the country in all phases of that litigation, from its very earliest stages through trial and into post-trial appellate work. And that's it.
We had also hoped to have with us today Jessica Mayer, who is a Vice President and Managing Counsel of Cardinal Health based in Columbus, Ohio. But unfortunately, she had an emergency earlier this morning and isn't.
Tools these days, technology is, completely different than it was 20 years ago. And so, figuring out in advance what sort of technology you're going to use for your document review, whether you're going to use predictive coding, figuring out what vendor you're going to use to get that done needs to happen very early on, so that you can get way ahead of the 8 ball, so that when your initial disclosures are due or when the plaintiffs start seeking documents, you're not starting from square one. You're actually, moving down the road of being prepared to actually produce documents that, ultimately, more than likely, you're going to have to produce. So spending the time and the resources to do these two things early on is well worth it. The case is not going to go away if it's this sort of case. This work is going to have to get done, and there's no reason not to sort of start it immediately in most situations. And then on the law, it obviously depends on what kind of case it is, but particularly if it's some sort of a novel lawsuit or a class action, these kinds of cases, you want to put together a legal team to really start thinking about what the legal issues are going to be, sort of soup to nuts. You may have early motions to dismiss. You may have, you may want to deal with the class certification issues early, but all of those things are going to fold into a long-term legal strategy. And so, even very early in the case, you want to think about, what your appellate issues are going to be, and your strategy on the legal front needs to start early and think all the way through to sort of your end game. And so putting together a legal team early on, oftentimes, in my view, it's helpful to have folks from different law firms because they can play sort of a checks and balance on each other. But to put together a group to think through all the legal issues early makes a lot of sense. And then in terms of the risks involved, in your initial assessment, you obviously have to take into account the risks. If they're safety risks, you've got issues related to, whether the product should stay on the market or be removed. You've got the economic risks, which relate to the potential liability that the company is facing, particularly if there are punitive damages involved in the case, which there typically are in these scenarios. And then, of course, Maury mentioned before the risks of potentially having.
and on a company-wide basis, the development of large numbers of expert witnesses involving what can often be highly specialized and broad scientific and medical areas. We believe that one of the keys to managing this litigation and organizing the company's defense is work that's done at the very beginning to create an initial assessment of what the issues are and how the litigation could proceed, which brings us to slide 6, and Daphne is going to talk about that.
Thanks, Maury. Yeah, I mean, obviously, one of the first things you have to do when you get sued in this context is identify who are the key players, who are the company employees who may or may not still be at the company, who were involved with the facts surrounding the case. And it's important to identify those people early because oftentimes, if you've got plaintiff's lawyers who are savvy and sophisticated, they will try to take discovery very early on because they want to get to the witnesses before they're well prepared, before they have spent lots of time with the lawyers, understanding number one how to testify, and number two, what the company story is. And so it's important to identify those people and also to really begin preparing them. A lot of times the folks in the company and former employees who are involved with the facts have never testified before. And so, not only is it sort of marshaling all the facts that you're going to want to tell, the story with, but it's also preparing those people to be witnesses, which, as many of you know, sometimes doesn't come intuitively. So identifying the key employees and then assigning lawyers to spend time with those key employees is critical, and it's critical to get that done, I think, very early on. The other thing is, of course, the documents. As what happens a lot of times in these types of cases is the plaintiff's lawyers will use discovery as a weapon. They'll seek documents, particularly in courts where they have some sway with the judges, and they'll try to get them on a very short timeline. And so before any of that begins, it's important to figure out where your documents are, come up with a plan for how you're going to locate and review documents. There are so many wonderful